Multiple citizenship, also called dual citizenship or multiple nationality, is a person's citizenship status, in which a person is concurrently regarded as a citizen of more than one state under the laws of those states. There is no international convention which determines the nationality or citizen status of a person, which is defined exclusively by national laws, which vary and can be inconsistent with each other. Multiple citizenship arises because different countries use different, and not necessarily mutually exclusive, criteria for citizenship. Colloquial speech refers to people holding multiple citizenship, but technically each nation makes a claim that this person be considered its national. Some countries do not permit dual citizenship. This may be by requiring an applicant for naturalisation to renounce all existing citizenships, or by withdrawing its citizenship from someone who voluntarily acquires another citizenship, or by other devices. Some permit a general dual citizenship while others permit dual citizenship but only of a limited number of countries. Most countries which permit dual citizenship still may not recognize the other citizenship of its nationals within its own territory, for example in relation to entry into the country, national service, duty to vote, etc. Similarly, it may not permit consular access by another country for a person who is also its national. Some countries prohibit dual citizenship holders from serving in their military, on police forces or holding certain public offices. Citizenship of multiple countries. Who is regarded as a citizen and the rights of citizenship are determined by each country, which sets its own criteria for citizenship. These laws may create situations where a person may satisfy the citizenship requirements of more than one country simultaneously. This would, in the absence of laws of one country or the other, allow the person to hold multiple citizenships. National laws may include criteria as to the circumstances, if any, in which a person may concurrently hold another citizenship. A country may withdraw its own citizenship if a person acquires a citizenship of another country, for example, citizenship by descent. Historically, citizenship was traced through the father, but today most countries permit the tracing through either parent, and some also through a grandparent. Today, the citizenship laws of most countries are based on jus sanguinis. In many cases, this basis for citizenship also extends to children born outside the country, and sometimes even when the parent has lost citizenship. Citizenship by birth on the country's territory. Canada, the United States and many Latin American countries grant unconditional birthright citizenship. To stop birth tourism, most countries have abolished it. While Australia, France, Germany, Ireland, New Zealand, South Africa, and the United Kingdom have a modified jus soli, which requires at least one parent to be a citizen of the country or a legal permanent resident who has lived in the country for several years. Citizenship by marriage. Some countries routinely give citizenship to spouses of its citizens, or may shorten the time for naturalization, but only in a few countries is citizenship granted on the wedding day. Some countries have regulations against so-called sham marriages, and some revoke the spouse's citizenship if the marriage terminates within a specified time. Citizenship by naturalization. Citizenship by adoption. A minor adopted from another country when at least one adoptive parent is a citizen. Citizenship by investment. Some countries give citizenship to people who make a substantial monetary investment in a country. For example, Austria, Cyprus, Dominica and St. Kitts and Nevis grant citizenship immediately, without a requirement for any presence in the country. Some countries grant citizenship based on religion. Israel gives all Jews the right to immigrate to Israel, by the law of return, and fast-tracked citizenship. Dual citizenship is permitted, but when entering the country the Israeli passport must be used. The Algerian Nationality Law grants citizenship only to Muslims whose father and paternal grandfather were Muslims. In the Maldives, on August 7, 2008, President Mohammed Abdul Gayoom enacted a law that allows only Muslims to become citizens of the Maldives. Citizenship by holding an office. In the case of Vatican City, citizenship is based on holding an office, with Vatican's citizenship held by the Pope, cardinals residing in Vatican City, active members of the Holy See's diplomatic service, and other directors of Vatican offices and services. Vatican's citizenship is lost when the office term comes to an end, and children cannot inherit it from their parents. Since Vatican's citizenship is time-limited, dual citizenship is allowed, and persons who would become stateless because of loss of Vatican's citizenship automatically become Italian citizens. Once a country bestows citizenship, it may or may not consider a voluntary renunciation of that citizenship to be valid. In the case of naturalization, some countries require applicants for naturalization to renounce their former citizenship. For example, United States Chief Justice John Rutledge ruled a man may, at the same time, enjoy the rights of citizenship under two governments, but the U.S. requires applicants for naturalization to swear to an oath renouncing all prior allegiance and fidelity to any other nation or sovereignty as part of the naturalization ceremony. However, some countries do not recognize one of its citizens renouncing its citizenship. Effectively, the person in question may still possess both citizenships, notwithstanding the technical fact that he or she may have explicitly renounced one of the country's citizenships before officials of the other. For example, the United Kingdom recognizes a renunciation of citizenship only if it is done with competent UK authorities. Consequently, British citizens naturalized in the United States remain British citizens in the eyes of the British government even after they renounce British allegiance to the satisfaction of United States authorities. Irish nationality law applies to the island of Ireland, which extends citizenship to Northern Ireland, which is part of the United Kingdom. Therefore, anyone born in Northern Ireland who meets the requirements for being an Irish citizen through birth on the island of Ireland can exercise rights accorded only to Irish citizens, including that of travelling under an Irish passport. Under Irish law, even if such a person has not acted in this way, it does not necessarily mean that they are not entitled to Irish citizenship. People born in Northern Ireland are also British citizens on the same basis as people born elsewhere in the United Kingdom. People born in Northern Ireland may choose to hold a British passport, an Irish passport, or both. Multiple citizenship avoided. Some countries consider multiple citizenship undesirable and take measures to avoid it. Since a country only has control over who has its citizenship, but has no control over who has any other country's citizenship, the only way for a country to avoid multiple citizenship is to deny its citizenship to people in cases when they would have another citizenship. This may take the following forms: automatic loss of citizenship if another citizenship is acquired voluntarily, such as Azerbaijan, mainland China, Denmark, India, Indonesia, Japan, Kazakhstan, Nepal, the Netherlands, Norway. Saudi Arabian citizenship may be withdrawn if a Saudi citizen obtains a foreign citizenship without the permission of the Prime Minister. Possible loss of citizenship if another citizenship is acquired voluntarily, such as Singapore, Malaysia, South Africa. Possible loss of citizenship if people with multiple citizenships do not renounce their other citizenships after reaching the age of majority or within a certain period of time after obtaining multiple citizenships, such as Japan and Montenegro. In Montenegro, loss is automatic with some exceptions. Denying automatic citizenship from birth if the child may acquire another citizenship automatically at birth. Requiring an applicant for naturalization to apply to renounce his/her existing citizenship, and provide proof from those countries that they have renounced citizenship, as a condition of naturalization. Complex laws on dual citizenship. Some countries do not simply allow or forbid dual or multiple citizenship in general, but have more complex rules on it. For example, some countries allow dual citizenship, but restrict the rights of dual citizens. For example, in Australia and Egypt, dual citizens cannot be elected to parliament. In the United States, naturalized citizens cannot run for the offices of president or vice president, who must be natural-born citizens, but they can hold any other office. Germany and Austria for the most part do not permit dual citizenship except for persons who obtain more than one citizenship at the time of birth. Germans and Austrians can apply for special permission to keep their citizenship before taking a second one. In general, however, any Austrian who takes up a second citizenship will automatically lose Austrian citizenship. Since August 2007, Germany has recognized dual citizenship if the other citizenship is either one of an EU member country or a Swiss citizenship, so that a permission is not required anymore in these cases, and in some exceptional cases, non-EU and non-Swiss citizens can keep their old citizenship when they become citizens of Germany. For more details, see German nationality law dual citizenship. Due to changes of the German law on dual citizenship, children of non-EU legal permanent residents can have dual citizenship if born and grown up in Germany. Acquisition of the nationality of Andorra, Portugal, the Philippines, Equatorial Guinea or Latin American countries, is not sufficient to cause the loss of Spanish nationality by birth. Spain has dual citizenship treaties with Argentina, Bolivia, Chile, Colombia, Costa Rica, the Dominican Republic, Ecuador, Honduras, Guatemala, Nicaragua, Paraguay, Peru, and Puerto Rico. Spaniards residing in these countries do not lose their rights as Spaniards if they adopt that nationality. For all other countries, Spanish citizenship is lost 3 years after the acquisition of the foreign citizenship unless the individual declares officially they will to retain Spanish citizenship. Upon request, Spain has allowed persons from Puerto Rico to acquire Spanish citizenship. On the other hand, foreign nationals that acquire the Spanish nationality lose their previous nationality, unless they were natural-born citizens of an Ibero-American country, Andorra, the Philippines, Equatorial Guinea or Portugal, even if these countries do not grant their citizens a similar treatment. See also the section on dormant citizenship. Prior to 2011, South Korea did not permit dual citizenship after the age of 21. Now a limited number of persons can have it. For details, see South Korean nationality law dual citizenship. Like Germans and Austrians, citizens of South Africa must apply for a permission to keep their citizenship, or they will lose their South African citizenship when acquiring the citizenship of another country. The Turkish government requires that Turkish citizens who apply for another nationality inform the appropriate Turkish officials and provide the original naturalization certificate, Turkish birth certificate, document showing completion of military service, marriage certificate and 4 photographs. Dual nationals are not compelled to use a Turkish passport to enter and leave Turkey. It is permitted to travel with a valid foreign passport and the Turkish national ID card. Pakistan allows dual citizenship with only 16 countries: Australia, Belgium, Canada, Egypt, France, Iceland, Ireland, Italy, Jordan, the Netherlands, New Zealand, Sweden, Switzerland, Syria, the United Kingdom, and the United States. EU and EFTA countries and European microstates. The EU and EFTA countries have various policies regarding dual citizenship, because each country can make its own laws. The only real rule is that a citizen of an EU country can live and work indefinitely in other EU countries and in the 4 EFTA countries. However, the right to vote and work in certain sensitive fields might in some cases be restricted to the local citizens only. The countries can exempt immigrants from getting welfare in the first 3 months to avoid welfare tourism, and they can refuse welfare completely if the immigrants do not have a job and do not try to get one. The 4 microstates are no EU or EFTA members. For details, see the nationality law of the country concerned and citizenship of the European Union. As of April 2014, 14 out of 28 EU countries restrict or forbid dual citizenship. Austria, dual citizenship is possible with special permission or if it was obtained at birth. Belgium, allows dual citizenship. Bulgaria, Bulgarian citizens of descent can have dual citizenship, but foreigners wanting to naturalize must renounce their old citizenship. Croatia, generally allows citizens by descent to have dual citizenship and forbids it only in certain cases, but foreigners wanting to naturalize must renounce their old citizenship. Cyprus, allows dual citizenship. Northern Cyprus is not generally recognized by the international community as a sovereign state. No nation other than Turkey has officially recognized Northern Cyprus. The United Nations considers the Declaration of Independence by Northern Cyprus as legally invalid, as enunciated in several of its resolutions. The United Nations recognizes Northern Cyprus as territory of the Republic of Cyprus under Turkish occupation. Turkey permits citizens of Northern Cyprus to live and work in Turkey under the same requirements as Turkish citizens, and provides a special type of passport for Northern Cyprus citizens. Despite the ethnic and physical division of Turkish Cypriots from the rest of Cyprus, they can obtain Cypriot passports and ID cards if they prove to be Cypriots by descent. Turkish settlers in the northern part of Cyprus are not entitled to Cypriot citizenship. Czech Republic, dual citizenship is permitted to Czech citizens who acquire a second citizenship by birth, through marriage and newly by accepting a citizenship of another state. On the other hand, foreign nationals can apply for and obtain the Czech citizenship by meeting the requirements of the Citizenship Act without losing their original citizenship unless they wish to do so or are required to do it by their original home state or international treaties. The final decision as to whether or not the Czech citizenship should be granted is not of the character of legal entitlement per se, rather it is vested in the discretion of the respective state authorities. Denmark, currently, it is a fundamental principle in the legislation to restrict dual nationality as much as possible. One exception to this is if a person is born of a Danish parent in a country that grants citizenship under the principle of jus soli. On June 4, 2014, Parliament approved a law allowing dual citizenship. The new law will permit foreigners to become Danish citizens without having to give up the citizenship of their own country, and it will also allow Danes who have given up their citizenship for another to be able to reclaim it. The law change is expected to come into force in the summer of 2015. Estonia forbids dual citizenship, but citizens by descent cannot be deprived of their Estonian citizenship, so they de facto can have dual citizenship. Finland allows dual citizenship. France allows dual citizenship. Germany allows dual citizenship with other EU countries and Switzerland. Dual citizenship with other countries is possible with special permission or if obtained at birth. Children of non-EU non-Swiss legal permanent residents can have dual citizenship if born and grown up in Germany. Greece allows dual citizenship. Hungary grants dual citizenship to people living in, and having ancestors in territories which were annexed from Hungary at the end of World War I, provided they can still speak Hungarian. Ireland allows dual citizenship, but a naturalized citizen can lose Irish citizenship again when naturalizing in another country. Ireland was the last European country to abolish unconditional birthright citizenship, in 2004, in order to stop birth tourism, and to replace it by a modified form, at least one parent must be a citizen or a legal permanent resident. Italy allows dual citizenship. Latvia, from October 1, 2013, dual citizenship with Latvia is allowed for citizens of member countries of EU, NATO and EFTA, Iceland, Liechtenstein, Norway, Switzerland. Citizens of Australia, Venezuela, Brazil, New Zealand. Citizens of the counties that have mutual recognition of dual citizenship with Latvia. People who were granted the dual citizenship by the Cabinet of Ministers of Latvia. People who have applied for dual citizenship before the previous Latvian citizenship law, 1995. Lithuania. The Lithuanian constitution states in Article 12 that only in individual cases provided for by law can dual citizenship be permitted. Constitution of the Republic of Lithuania, adopted on October 25, 1992, in force from November 2, 1992. Luxembourg allows dual citizenship. Malta allows dual citizenship. Netherlands, dual citizenship is allowed under certain conditions, for example foreign citizenship may be kept if obtained at birth or in the event of naturalization via marriage. Poland does not deal with the issue of dual citizenship, but possession of another citizenship is tolerated since there are no penalties for its possession alone. However, penalties do exist for exercising foreign citizenship, such as identifying oneself to Polish authorities using a foreign identification document or serving in a foreign military without permission of Polish military authorities. Dual citizens are not exempted from their duties as Polish citizens. Under some circumstances, ethnic Poles can apply for the Polish card, Karta Polaka. Portugal allows dual citizenship. Romania allows dual citizenship. Slovakia, dual citizenship is permitted to Slovak citizens who acquire a second citizenship by birth or through marriage, and to foreign nationals who apply for Slovak citizenship and meet the requirements of the Citizenship Act. Please note that after the Hungarian Slovak citizenship conflict, some restrictions to dual citizenship may apply. Slovenia generally allows citizens by descent to have dual citizenship and forbids it only in certain cases, but foreigners wanting to naturalize must renounce their old citizenship. Spain, Spanish citizens by descent can have dual citizenship. Spanish laws knows a dormant citizenship for citizens naturalizing in Ibero-American countries. They do not lose their citizenship, but their status and their rights as citizens of Spain and of the Euro are inactive until they move back to Spain. Foreigners wanting to naturalize in Spain must usually renounce their old citizenship. Exceptions are made for citizens of some Ibero-American countries, Puerto Rico, Andorra, the Philippines, Equatorial Guinea, and Portugal. Since 2014, Spain has granted Spanish nationality to Sephardi Jews regardless their nationality. Sweden allows dual citizenship. United Kingdom allows dual citizenship. British and Danish citizens not regarded as EU citizens. The Channel Islands of Guernsey and Jersey and the Isle of Man are British Crown dependencies. Unlike the United Kingdom proper and Gibraltar, the Crown dependencies are not considered part of the EU for most purposes. The Faroe Islands belong to Denmark, but not the EU, so their inhabitants are Danish citizens, but not EU citizens. Greenland left the EC in 1985, but Greenlanders are considered EU citizens. These British and Danish citizens get local passports. They can become full EU citizens by moving to and living permanently in the United Kingdom or in Denmark. British citizens bearing passports from the Crown dependencies but having sufficient connections to the UK proper or Gibraltar are considered EU citizens. The 4 microstates surrounded by EU countries, these 4 countries are not EU or EFTA members, and only Vatican City grants dual citizenship. Andorra, Monaco, and San Marino forbid it. In 2012, however, 78% of the 36,000 inhabitants of Monaco were foreigners and not citizens. See also Andorran Nationality Law and Nationality Law of Monaco. EFTA countries, Iceland allows dual citizenship. See also Icelandic Nationality Law. Liechtenstein allows citizens by descent to have dual citizenship, but foreigners wanting to naturalize must renounce their old citizenship. Norway allows dual citizenship only in exceptional cases. A Norwegian citizen who voluntarily acquires another citizenship automatically loses Norwegian citizenship without notification, and foreigners wanting to naturalize must usually renounce their old citizenship. For details, see Norwegian Nationality Law, dual citizenship. Switzerland allows dual citizenship, but the conditions for the naturalization of foreigners vary from canton to canton. Male Swiss citizens under the age of 25, including male dual citizens, are required to perform military or civilian service, and Swiss citizens are not allowed to work for a foreign military. Foreign military service is a felony for Swiss citizens. In the canton of Schaffhausen, voting is compulsory. For more details, see Swiss Nationality Law on Schweizer 1 Quarter Direct. The Nordic Passport Union. The Nordic Passport Union allows citizens of the Nordic countries of Denmark, Sweden, Norway, Finland, and Iceland to travel and reside in other Nordic countries without a passport or a residence permit. However, Denmark and Norway forbid dual citizenship. Partial citizenship. Many countries allow foreigners or former citizens to live and work indefinitely there. However, for voting, being voted and working for the public sector or the national security in a country, citizenship of the country concerned is almost always required. Since 2008, Poland has granted the Polish card to ethnic Poles who are citizens of the successor states of the former Soviet Union and can prove they have Polish ancestors and knowledge of the Polish language and declare their Polish ethnicity in written form. Holders of the card are not regarded as citizens, but enjoy some privileges other foreigners do not, for example entry visa, right to work, education, or healthcare in Poland. As stated above, Poland currently has no specific laws on dual citizenship. A second citizenship is tolerated, but not recognized. Turkey allows its citizens to have dual citizenship if they inform the authorities before acquiring the second citizenship, and former Turkish citizens who have given up their Turkish citizenship can apply for the blue card, which gives them some citizens' rights back, for example the right to live and work in Turkey, the right to possess land or the right to inherit, but not, for example, the right to vote. Overseas citizenship of India. The Constitution of India does not permit dual citizenship or dual nationality, except for minors where the second nationality was involuntarily acquired. Indian authorities interpreted this to mean a person cannot have another country's passport while simultaneously holding an Indian one, even for a child claimed by another country as its citizen, who may be required by the laws of this country to use the corresponding passports for foreign travel. Indian courts have given the executive branch wide discretion over this matter. In 2005, India amended the 1955 Citizenship Act to introduce a form of overseas citizenship, which stops just short of full dual citizenship and is, in all aspects, like permanent residency. Such overseas citizens are exempt from the rule forbidding dual citizenship. They may not vote, run for office, join the army, or take up government posts, though these evolving principles are subject to revolving political discretions if you are born in India with birthrights. Moreover, people who have acquired citizenship in Pakistan or Bangladesh are not eligible for overseas citizenship. Many countries issue permanent residency status to foreigners deemed eligible. This status generally authorizes one to live and work in the issuing country indefinitely, albeit subject to certain limitations and obligations. Usually, permanent residents can apply for citizenship after several years of residency in the country concerned. Depending both on the home country and the guest country, dual citizenship may or may not be permitted. In the latter case, permanent residents sometimes prefer not to naturalize, but to maintain their current status. For more details, see permanent resident. Some countries have concluded treaties regulating travel and access to the job markets. A citizen of an EU country can live and work indefinitely in other EU countries and in the 4 EFTA countries. The Trans-Tasman Travel Agreement between Australia and New Zealand allows citizens of the two countries to live and work in each other's neighbouring country. A citizen of a GCC member state can live and work in other member states, but dual citizenship is not allowed. Indian citizens do not need a visa to travel to and work in Nepal or Bhutan, but none of the three countries allows dual citizenship. Multiple citizenship not recognized. Saying that a country does not recognize multiple citizenship is a confusing and ambiguous term. Often, it is simply a restatement of the master nationality rule, which means that a country treats a multiple citizen, one of whose citizenships include that country's, no differently from a sole citizen of that country. In other words, the country does not recognize this multiple citizen person has multiple citizenships, for the purposes of the country's laws, even though the person may actually be regarded as a citizen by other countries according to their laws. In particular, this may mean that if you're a citizen of that country, you cannot use another country's passport or citizenship documents to enter or leave the country. Dormant citizenship and right of return. The concept of a dormant citizenship means that a person has the citizenships of two countries, but as long as he/she lives permanently in the one country, his/her status and citizens' rights in the other country are inactive. They will be reactivated when he/she moves back to and lives permanently in the other country. This means, in spite of dual citizenship, only one's citizenship can be exercised at a time. The dormant citizenship exists for example in Spain. Spanish citizens who have naturalized in an Ibero-American country and have kept their Spanish citizenship are technically dual citizens, but have lost their rights as Spanish or Euro, and Euro citizens until they move back to and live permanently in Spain. Some countries offer former citizens or citizens of former colonies of the country a simplified naturalization process. Depending on the laws of the two countries in question, dual citizenship is allowed or not. For details, see right of return. Multiple citizenship encouraged. Some countries are more open to multiple citizenship than others. since it may help citizens travel and conduct business overseas. Countries that have taken active steps towards permitting multiple citizenship in recent years include Switzerland and Australia. Today, most advanced economies allow dual citizenship. Notable exceptions that restrict or forbid it are Austria, Denmark, Germany, Japan, the Netherlands, Norway, Singapore, South Korea, and Spain. Of the newly industrialized countries, Brazil, Mexico, the Philippines, South Africa, Thailand, and Turkey allow dual citizenship, while China, India, and Malaysia forbid it. Indonesia allows dual citizenship only until the age of 18 years. In former times, some countries advertised their policy of unconditional birthright citizenship to become more attractive for immigrants. Despite wide acceptance of dual citizenship, industrialized countries now try to protect themselves from birth tourism and uncontrollable immigration waves, so only Canada and the United States still grant unconditional birthright citizenship. In both countries, there have been calls to change the laws, but, so far, they have not been successful. Brazil has similar policies. The only people born in Brazil who do not have Brazilian citizenship are the children of foreigners who abide Brazil while servicing their own country. In Australia, France, Germany, Ireland, New Zealand, South Africa, and the United Kingdom, a baby born there is regarded as a citizen only if at least one parent is either a citizen or a legal permanent resident who has lived there for several years. Some countries allow only citizens by descent to have dual citizenship, but require naturalized citizens to renounce their old citizenship. Dual citizenship by region. Africa. Most African countries restrict or forbid dual citizenship. It is allowed, for example, in Angola, Burundi, Cote d'Ivoire, Djibouti, Gabon, Gambia, Ghana, Kenya, Mali, Morocco, Mozambique, Nigeria, Rwanda, Senegal, Sao Tome Copyright and Principe, Sierra Leone, Sudan, Tunisia, and Uganda. Eritreans, Egyptians, and South Africans wanting to take another citizenship need a permission to maintain their citizenship. Lesotho restricts dual citizenship, but observes jus soli. The Americas. Most American countries allow dual citizenship. Some countries do not allow their citizens to renounce their citizenship, so they keep it even when naturalizing in a country that forbids dual citizenship. Most American countries observe unconditional jus soli, that is, a baby born there is regarded as a citizen even if the parents are not. Some countries allow renunciation of citizenship only if it was involuntarily acquired by birth to non-citizen parents. Canada and the United States allow dual citizenship and are worldwide the two only developed economies to grant unconditional birthright citizenship. Dual citizenship is restricted or forbidden, for example, in Haiti and Suriname. Asia-Pacific. Most countries in the Asia-Pacific region restrict or forbid dual citizenship. But in some of these countries, it is very difficult or even impossible for citizens to renounce their citizenship, even when naturalizing in another country. Dual citizenship is allowed, for example, in Australia, Fiji, New Zealand, Philippines, Samoa, Tonga, and Vanuatu. Cambodia allows dual citizenship and observes jus soli for children born to legal permanent residents born in Cambodia or to children whose parents are unknown. South Korea allows dual citizenship in limited circumstances. It allows foreign-born nationals who married to a Korean citizen, Korean men holding dual citizenship by birth who served in the Republic of Korea Armed Forces as compulsory military service, Korean women with multiple nationalities by birth who has vowed her intention not to exercise her foreign nationality in the Republic of Korea by the age of 22 and overseas Koreans at least 65 years of age. Taiwan and Hong Kong allow dual citizenship for citizens by birth, but do not permit applicants for naturalization to retain their prior citizenships. Israel allows dual citizenship. Pakistan restricts dual citizenship, but observes jus soli. In Papua New Guinea there was overwhelming support from Parliament to amend their constitution to allow dual citizenship, however the law had yet to come into force as of February 2014. In Sri Lanka, laws allowing dual citizenship are currently being discussed. Europe. Europe is divided over dual citizenship. In about half of the countries, it is allowed. In the other half, it is restricted or forbidden. For EU, EFTA and the European microstates, see above. The rest of Europe, Albania, Armenia, Moldova, Russia and Serbia allow dual citizenship. But in Russia, a second citizenship must be reported. Belarus and Kazakhstan forbid dual citizenship. Azerbaijan, Macedonia, and Montenegro generally do not allow dual citizenship. Ukrainian law currently does not recognize dual citizenship. However, there are citizens of Ukraine who hold dual citizenship. On February 8, 2014, the Rada proposed a bill to criminalize the act of holding two citizenships. Supranational citizenship. Under the 14th Amendment to the United States Constitution, all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they are deemed to reside. Certain rights accrue as an incident of state citizenship, and access to federal courts can sometimes be determined on state citizenship. Switzerland has a three-tier system of citizenship: confederation, canton and commune. Although considered part of the United Kingdom for British nationality purposes, the Crown dependencies of Jersey, Guernsey and the Isle of Man have local legislation restricting certain employment and housing rights to those with local status. Although the British citizenship of people from these islands gives them full citizenship rights when in the United Kingdom, it does not give them the rights that British citizenship generally confers when in other parts of the European Union. The Australian territory of Norfolk Island has immigration laws that restrict residence in the territory to those with local status. Most Norfolk Islanders are Australian citizens. Citizens of the People's Republic of China may be permanent residents of the Hong Kong or Macau Special Administrative Regions, or have household registration somewhere in mainland China. School enrollment, work permission, and other civic rights and privileges are tied to the region in which the citizen has permanent residence or household registration. Although within mainland China the hukou system has loosened in recent years, movement between Macau, Hong Kong, and/or the mainland remains controlled. Mainland Chinese who migrate to Hong Kong on one-way permits have their mainland hukou cancelled, while children born in Hong Kong to visiting mainland parents cannot receive mainland hukou unless they cancel their Hong Kong permanent resident status. People from a land have joint regional and national citizenship. People with Icelandic citizenship have the right to buy property and set up a business on a land, but Finns without regional citizenship cannot. Finns can get Icelandic citizenship after living on the islands for 5 years, and Islanders lose their regional citizenship after living on the Finnish mainland for 5 years. The government of Puerto Rico began issuing Puerto Ricans citizenship certificates in September 2007 after Juan Mari Braoes, a lifelong supporter of independence, won a successful court victory that validated his claim that Puerto Rican's citizenship was valid and can be claimed by anyone born on the island or with at least one parent who was born there. In Bosnia and Herzegovina, citizens hold also citizenship of their respective entity, which is generally the entity of their residence. It can be either citizenship of Republika Srpska or of the Federation of Bosnia and Herzegovina. One cannot hold both entity citizenships simultaneously. Following the federalization of Czechoslovakia in 1968, Czechoslovak citizens also possessed an internal citizenship of either the Czech or Slovak Republic. Upon the nation's peaceful dissolution in 1993, this was used to determine whether they ought to receive Czech or Slovak citizenship. Before the breakup of Yugoslavia in 1991, Yugoslav citizens possessed an internal citizenship of their own republic as well as Yugoslav citizenship. In Serbia and Montenegro, this system was in effect until 2006. Supranational citizenship. In European Union law there is the concept of EU citizenship which flows from citizenship of a member state. A citizen of an EU country is free to live and to work in another EU country for an unlimited period of time, but member states may reserve the right to vote in national elections, stand for national election, become a public servant in highly sensitive ministries, etc. only for their citizens. an EU state may place restrictions on the free movement rights of citizens of newly admitted states for several years. Such provisions remain in force mostly for nationals of Croatia. In the past, and to a lesser extent, such provisions also affected Estonia, Latvia, Lithuania, Poland, the Czech Republic, Slovakia, Hungary, Slovenia, Bulgaria and Romania. The Commonwealth of Nations has a Commonwealth citizenship for the citizens of its members. Some member states allow non-nationals who are Commonwealth citizens to vote and stand for election while resident there. Others make little or no distinction between citizens of other Commonwealth nations and citizens of non-Commonwealth nations. Commonwealth of Independent States nations are often eligible for fast-track processing to citizenships of other CIS countries, with varying degrees of recognition tolerance of dual citizenship among the states. Potential issues: national cohesiveness. Some have questioned whether allowing dual citizenship impedes cultural assimilation, increases disconnection from the political process, and degrades national identity cohesiveness. The rise in tension between mainstream and migrant communities is cited as evidence of the need to maintain a strong national identity and culture. They assert that the fact that a second citizenship can be obtained without giving anything up both trivializes what it means to be a citizen and nullifies the consequential, transformational, and psychological change that occurs in an individual when they go through the naturalization process. In effect, this approach argues, the self-centered taking of an additional citizenship contradicts what it means to be a citizen in that it becomes a convenient and painless means of attaining improved economic opportunity without any real consequences and can just as easily be discarded when it is no longer beneficial. Proponents argue that dual citizenship can actually encourage political activity, providing an avenue for immigrants who are unwilling to forsake their country of origin either out of loyalty or due to a feeling of separation from the mainstream society because of language, culture, religion, or ethnicity. A 2007 academic study concluded that dual citizens had a negative effect on the assimilation and political connectedness of first-generation Latino immigrants to the United States, 32% less likely to be fluent in English, 18% less likely to identify as American, 19% less likely to consider the U.S. as their homeland, 18% less likely to express high levels of civic duty, 9% less likely to register to vote, 15% less likely to have ever voted in a national election. The study also noted that although dual nationality is likely to disconnect immigrants from the American political system and impede assimilation, the initial signs suggest that these effects seem to be limited almost exclusively to the first generation. Concern over the effect of multiple citizenship on national cohesiveness is generally more acute in the United States. The reason for this is twofold. The United States is a civic nation and not an ethnic nation. American citizenship is not based on belonging to a particular ethnicity, but on political loyalty to American democracy and values. Regimes based on ethnicity, which support the doctrine of perpetual allegiance as one is always a member of the ethnic nation, are not concerned with assimilating non-ethnics since they can never become true citizens. In contrast, the essence of a civic nation makes it imperative that immigrants assimilate into the greater whole, as there is not an ethnic cohesiveness uniting the populace. The United States is an immigrant nation. It has prospered due to its immigration policy of taking in and absorbing a very diverse stock of immigrants. As immigration is primarily directed at family reunification and/or refugee status rather than education and job skills, the pool of candidates tends to be poorer, less educated, and consistently from less stable countries with less familiarity or understanding of American values, making their assimilation both more difficult and more important. The degree of angst over the effects of dual citizenship seemingly corresponds to a country's model for managing immigration and ethnic diversity, the differential exclusionary model, which accepts immigrants as temporary guest workers, but is highly restrictive with regard to other forms of immigration and to naturalization of immigrants. Japan, China, Taiwan, and the countries of the Middle East tend to follow this approach. The Assimilationist Model, which accepts that immigrants obtain citizenship, but on the condition that they give up some or all cultural, linguistic, or social characteristics that differ from those of the majority population. Europe is the primary example of this model, where immigrants are usually required to learn the official language, and cultural traditions such as Islamic dress are often barred in public spaces. The multicultural model, which grants immigrants access to citizenship and to equal rights without demanding that they give up cultural, linguistic, and/or intermarriage restrictions or otherwise pressure them to integrate or intermix with the mainstream population. Canada, Australia, and the United States have historically taken this approach, as exemplified by the fact that the United States has no official language, allowing official documents such as election ballots to be printed in a variety of languages. Appearance of foreign allegiance: people with multiple citizenship may be viewed as having dual loyalty, having the potential to act contrary to a government's interests, and this may lead to difficulties in acquiring government employment where security clearance may be required. In the United States, dual citizenship is associated with two categories of security concerns: foreign influence and foreign preference. Contrary to common misconceptions, dual citizenship in itself is not the major problem in obtaining or retaining security clearance in the United States. As a matter of fact, if a security clearance the applicant's dual citizenship is based solely on parents' citizenship or birth in a foreign country, that can be a mitigating condition. However, taking advantage of the entitlements of a non-U.S. citizenship can cause problems. For example, possession and/or use of a foreign passport is a condition disqualifying one from security clearance and is not mitigated by reasons of personal convenience, safety, requirements of foreign law, or the identity of the foreign country, as is explicitly clarified in a Department of Defense policy memorandum which defines a guideline requiring that any clearance be denied or revoked unless the applicant surrenders the foreign passport or obtains official permission for its use from the appropriate agency of the United States government. This guideline has been followed in administrative rulings by the United States Department of Defense Defense Office of Hearings and Appeals Office of Industrial Security Clearance Review, which decides cases involving security clearances for contractor personnel doing classified work for all DoD components. In one such case, an administrative judge ruled that it is not clearly consistent with U.S. national interest to grant a request for a security clearance to an applicant who was a dual national of the U.S. and Ireland, despite the fact that it has with good relations with the U.S. In Israel, certain military units, including most recently the Israeli Navy's submarine fleet, as well as posts requiring high security clearances, require candidates to renounce any other citizenship before joining, though the number of units making such demands has declined. In many combat units, candidates are required to declare but not renounce any foreign citizenship. On the other hand, Israel may view some dual citizens as desirable candidates for its security services due to their ability to legitimately enter neighboring states which are close to Israeli passport holders. The related case of Ben Zigia has caused debate about dual citizenship in Australia. Multiple citizenship among politicians: this perception of dual loyalty can apply even when the job in question does not require security clearance. In the United States, dual citizenship is common among politicians or government employees. For example, Arnold Schwarzenegger retained his Austrian citizenship during his service as a governor of California. In 1999, the U.S. Attorney General's office issued an official opinion that a statutory provision that required the Justice Department not to employ a non-citizen of the United States did not bar it from employing dual citizens. In Germany, politicians can apparently have dual citizenship with other EU countries or Switzerland. David McAllister, who holds British and German citizenship, was Minister-President of the state of Lower Saxony from July 1, 2010 to February 19, 2013. He was the first German minister-president to hold dual citizenship. Non-EU non-Swiss dual citizenship is not allowed, so, for example, Alliance 90/The Greens politician Semir Zdemir, son of Turkish immigrants, holds only German citizenship. A small controversy arose in 2005 when Michael Jean was appointed the Governor-General of Canada. Although Jean no longer holds citizenship in her native Haiti, her marriage to French-born filmmaker Jean-Daniel Lafond allowed her to obtain French citizenship several years before her appointment. Article 23-8 of the French Civil Code allows the French government to withdraw the French nationality from French citizens holding government or military positions in other countries, and Jean's appointment made her both de facto head of state and commander-in-chief of the Canadian forces. The French embassy released a statement that this law would not be enforced because the Governor-General is essentially a ceremonial figurehead. Nevertheless, Jean renounced her French citizenship 2 days before taking up office to end the controversy about it. However, former Canadian Prime Minister John Turner was born in the United Kingdom and still retains his dual citizenship. Star copyright Fane Dion, former head of the Liberal Party of Canada and the previous leader of the official opposition, holds dual citizenship with France as a result of his mother's nationality. Dion nonetheless indicated a willingness to renounce French citizenship if a significant number of Canadians viewed it negatively. Thomas Muller, leader of the NDP and opposition leader of the Canadian House of Commons, also holds dual citizenship with France. In Egypt, dual citizens cannot be elected to Parliament. The Constitution of Australia, in Section 44(I), explicitly forbids people who hold foreign citizenship from sitting in the Parliament of Australia. A court case determined that the UK is a foreign power for purposes of this section of the Constitution, despite Australia holding a common nationality with it at the time that the Constitution was written, and that Senator-elect Heather Hill had not been duly elected to the national parliament because at the time of her election she was a subject or citizen of a foreign power. However, the High Court of Australia also ruled that dual citizenship on its own would not be enough to disqualify someone from validly sitting in Parliament. The individual circumstances of the non-Australian citizenship must be looked at, although the person must make a reasonable effort to renounce their non-Australian citizenship. However, if that other citizenship cannot be reasonably revoked, such as it being impossible under the laws of the other country or practically impossible as requiring an extremely difficult revocation process, then that person will not be disqualified from sitting in Parliament. In New Zealand, controversy arose in 2003 when Labour MP Harry Duynhoven applied to renew his citizenship of the Netherlands. Duynhoven, the New Zealand-born son of a Dutch-born father, had possessed dual citizenship from birth but had temporarily lost his Dutch citizenship due to a 1995 change in Dutch law regarding non-residents. While New Zealand's Electoral Act allowed candidates with dual citizenship to be elected as MPs, Section 55 of the Act stated that an MP who applied for citizenship of a foreign power after taking office would forfeit his/her seat. This was regarded by many as a technicality, however. And Duynhoven, with his large electoral majority, was almost certain to re-enter Parliament in the event of a by-election. As such, the Labour government retrospectively amended the Act, thus enabling Duynhoven to retain his seat. The amendment, nicknamed Harry's Law, was passed by a majority of 61 votes to 56. The revised Act allows exceptions to Section 55 on the grounds of an MP's country place of birth, descent, or renewing a foreign passport issued before the MP took office. Both the current Estonian President Toomas Hendrickilps and the former Lithuanian President Valdas Adamkus had been naturalized U.S. citizens prior to assuming their offices. Both have renounced their U.S. citizenships, Ilves in 1993 and Adamkus in 1998. This was necessary because neither individual's new country permits retention of a former citizenship. Adamkus was a high-ranking official in the Environmental Protection Agency, a federal government department, during his time in the United States. Taxation. In some cases, multiple citizenship can create additional tax liability. Most countries that impose tax normally base tax liability on source and/or residency. Only 2 countries tax their non-resident citizens on foreign income, the United States and Eritrea. Residency: a country may tax the income of anyone who lives there, regardless of citizenship or whether the income was earned in that country or abroad. Source: a country may tax any income generated there, regardless of whether the earner is a citizen, resident, or non-resident. Or, citizenship: a country may tax the worldwide income of his citizens, regardless of whether they reside in that country or whether the income was sourced there. A few other countries tax based on citizenship in limited situations: Finland, France, Hungary, Italy, and Spain. Only U.S. expatriates are subject to tax on all of their worldwide income, although U.S. law provides measures to reduce or eliminate double taxation issues for some expatriates. It has been reported that some U.S. expatriates have renounced U.S. citizenship in order to avoid this tax burden. A person with multiple citizenship may have a tax liability to his country of residence and also to one or more of his countries of citizenship. Or worse, if unaware that one of his citizenships created a tax liability, that country may consider the person to be a tax evader. Many countries and territories have contracted tax treaties or agreements for avoiding double taxation. Still, there are cases in which a person with multiple citizenship will owe tax solely on the basis of holding one of those citizenships. For example, consider a person who holds both Australian and United States citizenship, lives and works in Australia. He would be subject to Australian taxation, because Australia taxes its residents, and he would be subject to U.S. taxation because he holds U.S. citizenship. In general, he would be allowed to subtract the Australian income tax he paid from the U.S. tax that would be due. Plus, the U.S. will allow some parts of foreign income to be exempt from taxation. For instance, in 2006 the foreign earned income exclusion allowed up to $82,400 of foreign salaried income to be exempt from income tax. This exemption, plus the credit for foreign taxes paid mentioned above, often results in no U.S. taxes being owed, although a U.S. tax return would still have to be filed. In instances where the Australian tax was less than the U.S. tax, and if there was income that could not be exempted from U.S. tax, the U.S. would expect any tax due to be paid. The United States Internal Revenue Service has excluded some regulations such as alternative minimum tax from tax treaties that protect double taxation. In its current format, even if U.S. citizens are paying income taxes at a rate of 56%, far above the maximum U.S. marginal tax rate, the citizen can be subject to U.S. taxes because the calculation of the alternative minimum tax does not allow full deduction for taxes paid to a foreign country. Other regulations such as the post date of foreign mail tax returns are not recognized and can result in penalties for late filing if they arrive at the IRS later than the filing date. However, the filing date for overseas citizens has a 2-month automatic extension to the 15th of June. If you are a U.S. citizen or resident alien residing overseas, or are in the military on duty outside the U.S., on the regular due date of your return, you are allowed an automatic 2-month extension to file your return and pay any amount due without requesting an extension. For a calendar year return, the automatic 2-month extension is to June 15. If you are unable to file your return by the automatic 2-month extension date, you can request an additional extension to October 15 by filing Form 4868 before the automatic 2-month extension date. However, any tax due payments made after June 15 will be subject to both interest charges and failure to pay penalties. Issues with international travel. Many countries, even those that permit multiple citizenship, do not explicitly recognize multiple citizenship under their laws. Individuals are treated either as citizens of that country or not, and their citizenship with respect to other countries is considered to have no bearing. This can mean that consular officials abroad may not have access to their citizens if they also hold local citizenship. Some countries provide access for consular officials as a matter of courtesy, but do not accept any obligation to do so under international consular agreements. The right of countries to act in this fashion is protected via the Master Nationality Rule. Multiple citizens who travel to a country that claims them as a citizen may be required to enter or leave the country on that country's passport. For example, a United States Department of State web page on dual nationality contains the information that most U.S. citizens, including dual nationals, must use a U.S. passport to enter and leave the United States. Also, terms of the South African Citizenship Act, it is an offence for someone aged at least 18 with South African citizenship and another citizenship to enter or depart the Republic of South Africa using the passport of another country. They may also be required, before leaving the country, to fulfill requirements ordinarily required of its resident citizens, including compulsory military service or exit permits. See also, Canadians of convenience, History of citizenship, immigration, nationality, nationality law, naturalisation, Talbot v. Janssen, Taft Lauren Nace v. Moldova, Third Culture Kid, World Citizenship, References. Spanish Civil Code. Ministry of Justice of Spain. Further reading, Randall Hansen, Patrick Weil, ed. Dual Nationality, Social Rights and Federal Citizenship in the U.S. and Europe, The Reinvention of Citizenship. Burfan Books. ISBN A1-57181-804-9. Thomas Feist, ed. Dual Citizenship in Europe, From Nationhood to Societal Integration. Aldershot, UK, Ashgate. ISBN A978-0-7546-4914-4. Thomas Feist, Peter Cavisto, ed. Dual Citizenship in Global Perspective, From Unitary to Multiple Citizenship. Hound Mills, UK, Palgrave Macmillan. ISBN A978-0-230-00654-6. Thomas Feist and Jar 1/4 Gen Gerds. Dual Citizenship in an Age of Mobility. Transatlantic Council on Migration. Retrieved April 26, 2012. Federal Investigative Services Division of the U.S. Office of Personnel Management. Citizenship Laws of the World, a Directory. Retrieved January 28, 2008. External links. International, The Hague 1930 Convention, Convention No. 8 on the Exchange of Information Concerning Acquisition of Nationality, 1964, Council of Europe, Convention on the Reduction of Cases of Multiple Nationality and on Military Obligations in Cases of Multiple Nationality, 1963, European Convention on Nationality, 1997.